Hey, I think we are hitting our capacity for today, so we'll go ahead and get started. Good afternoon and welcome to Health Reform Beyond the Basics. Thanks for joining us for today's webinar on Medicaid eligibility appeals. For those of you who are Beyond the Basics regulars, this might be the second or even third webinar you're joining us for this month, so thank you for your interest in this these important topics. So my name is Jenny Sullivan, and I'm the director of Beyond the Basics. I'll be moderating today's webinar, which we are presenting in partnership with the National Health Law Program. Beyond the Basics is a project of the Center on Budget and Policy Priorities, and it's designed to provide training and resources to facilitate enrollment in the ACA health insurance marketplaces and Medicaid. The Center on Budget and Policy Priorities is a nonprofit policy organization. We are not part of the U.S. Department of Health and Human Services. We are also not able to offer continuing education credit for our webinars at this time. And finally, this webinar is not intended for press purposes. Next slide. I'm going to go ahead and put the slides in the chat again. For folks who join later, you'll see in the chat, you can click on that link and view today's slides. If you prefer to follow along on your own or make notes, they are available for you. So for logistics today, automated captions have been enabled for this webinar. To view them, click on the Show Captions icon at the bottom of your screen. That's the one with the 2 C's, and you'll be able to get live automated captions. All participants are muted and in listen-only mode. But if you'd like to ask a question, and we know many of you will, click on the Q&A icon at the bottom of your webinar screen and type your question into the box. I'll be monitoring the questions, and I will pause twice for Q&A during the presentation, or rather, Skylar, our presenter, will pause twice, once about halfway through, and then once again at the end. Now, we may not be able to answer every question asked. With a crowd this size, I wager that we will not be able to answer every question you ask, but we will have a record of all of your questions, and we'll use them as a guide for future resources and presentations. If you have questions that aren't answered during today's webinar that you still are wondering about, you are more than welcome to email them to us, and we will get right back to you after the webinar. And our email is beyondthebasics@cbpp.org. Just a note, you won't be able to click on your screen to go to any of the links that are shared in today's deck unless you open the link in the chat and open the deck on your browser. But we've put the link to the slides in the chat so you can download the slides at your convenience. And then after today's webinar, we will email a recording of the presentation along with the links to the slides and other resources to you. And everything will also be posted on our Beyond the Basics website. Next slide. Our presenter today is Skylar Rossellini, Senior Attorney with the National Health Law Program. Before joining NHeLP, Skylar was a Senior Attorney at Bay Area Legal Aid's Health Consumer Center, where he advocated for Bay Area residents' health access rights across 8 counties. Skylar worked on a range of issues, including eligibility and enrollment, access to health services, medical debt, and more for consumers insured through Medicaid, ACA marketplace coverage, and private insurance. Skylar, I'm going to turn it over to you now to say a little bit more about NHeLP and get us started.
Great, thank you. So I'm happy to be here and to do this presentation with you all. Just a little more about NHeLP. We are a national nonprofit organization that protects and advances the health rights of low-income and underserved individuals and families. This is primarily focused on Medicaid. That is our primary focus at our organization, and as well as other health access issues that are related to the ACA and Medicaid. NHeLP advocates, educates, and litigates at the federal and state levels. We also work at some local levels, local county levels, depending on the advocacy. If you want to find out more about our organization, you can go to healthlaw.org, and you can also follow us on social media if you're interested in learning more about our work. Next slide, please. So this is going to be our roadmap for today. We're going to go over some information about the what's currently happening right now with Medicaid that I think is top of many advocates' minds with the unwinding of the public health emergency. And then we're going to talk about appeals and the process, what is ripe for appeal, how to do it, and consumer rights during the appeals process, as well as some resources. I do want to just reiterate the appeals process we're discussing today is really focused on eligibility appeals. We're not going to get into service-related appeals. That's a whole other beast. And so we'll just be focusing on eligibility today. Next slide, please. So let's dive into the public health emergency unwinding and why this is relevant for this presentation today. Next slide. So the public health emergency unwinding, as you may know, officially the public health emergency, well, it was declared expired on the 11th, but there are certain services and programs that will end at the end of the month, but the 11th was the end date of the public health emergency. And we also had some changes in our federal laws that impacted some of the Medicaid specific protections during the public health emergency. Specifically, the Consolidated Appropriations Act of 2023 that was signed at the end of last year it changed some rules with the continuous coverage requirement during the public health emergency. The continuous coverage requirement under the federal laws during the public health emergency basically required state Medicaid agencies for enhanced federal funding during the public health emergency to keep people on their Medicaid, with a few exceptions. There were a few exceptions, but ensured that people stayed on their Medicaid coverage during the public health emergency. And so what that means is that, for about 3 years now, people have stayed on their Medicaid, and for, with a few exceptions, state Medicaid agencies have not been processing their renewals, redeterminations, and things like that. Now, the end of the continuous coverage requirement that was tied, like I said, to the public health emergency under previous federal rules, the Consolidated Appropriations Act changed that. It delinked that requirement to the public health emergency, and that expired on March 31st. So what that means is that with the new guidance, state Medicaid agencies have been able to begin initiating the renewals process for people on Medicaid as early as February 1st and as late as April 1st. And which means that some terminations may have occurred as early as April 1st. Now, just some broad strokes, kind of level setting here on what this unwinding process looks like, or unwinding period looks like. States have 12 months to initiate all redeterminations pending at the end of the continuous enrollment period. And they have 14 months, so an extra 2 months to complete those renewals. So they have to begin the process within 12 months, and they have to complete them within 14. And that's what's called the unwinding period. The states, and like I said, states unwinding period begins when they initiate the ex parte process for renewals that could result in termination. So when they look at available data that they have in their files and that they have in their data to renew someone's coverage, that's when their unwinding period begins. And like I said, it could begin as early as February, March, or April. And that means that terminations have begun either, between the period of April 1st of this year and July 1st of this year. And so that's really why this topic is so important, is because after 3 years, we anticipate that many state Medicaid agencies are going to see a lot of appeal requests. So I think this is a very timely topic. Next slide, please. I won't spend too much time on these next 2 slides, but these are just some visuals of what the unwinding process can look like. So you can refer to these, at your leisure, but this is just a diagram of states that have a 60-day renewal process. and the different timeline of when their unwinding periods begin, whether it's February, March, or April. And then on the next slide, this is the same diagram, but for states that have the 90-day renewal period. So again, you can take a look at this if you're more of a visual person like I am. Next slide. So what determinations can be appealed? When can someone ask for an appeal? What issues are ripe for a Medicaid appeal? Next slide, please. So it's really quite general. Beneficiaries who disagree with certain eligibility determinations made by their Medicaid agency have a right to appeal. If they don't like a decision that's being made on their Medicaid coverage, they essentially have the right to appeal that. They are entitled to that, to notice and hearings, and their right when adverse actions are taken against their Medicaid coverage. And that's under the Due Process Clause of the US Constitution. That's under Medicaid statutes and regulations. And it's under landmark decision Goldberg v. Kelly. If you do this kind of work, you are probably very familiar with that case. Very landmark decision, basically ensuring procedural due process requires evidentiary hearing before public assistance payments to welfare recipients are discontinued. And so that's really the foundation of Medicaid recipients' appeal rights. Next slide, please. So just unpacking what that means and what that actually looks like in practice. So a beneficiary can appeal when an adverse action is taken against their coverage. That could be if an application is denied. It could be if they've been covered, but it's been terminated. An adverse action could be if the scope of their coverage is either reduced or if it's suspended. Those are examples of adverse actions that would be ripe for appeal. Other actions could be when eligibility determinations are delayed. And that's because state agencies they have to act with reasonable promptness when there's a claim for assistance. And so that's sort of the general standard for that. And the one exception to, sort of this general right to an appeal is if the sole issue is a federal or state law requiring an automatic change that adversely affects some or all recipients. So an example of that right now is the optional COVID-19 uninsured group program. You may or may not be familiar with that program, but basically, in short, it's a temporary program that was permitted during the public health emergency, where states had the option to implement this program for individuals who were either uninsured or underinsured to access COVID-19 related testing or testing related services. Some states also threw in state dollars to cover COVID-19 related treatment services. And so this program automatically sunsets at the end of the public health emergency. And so because of that, this would not technically is not a population that has a right to a Medicaid appeal. So that's an example of what that actually looks like. Next slide, please. So like I said earlier, beneficiaries have a right to a notice for their appeal rights. They are entitled to specifically written notice at the time of application and at the time that actions are impacting their right to their Medicaid coverage. Notices need to be in plain language and they need to be accessible. They need to provide relevant dates on the adverse action. There needs to be a clear statement of specific reasons that support the agency's decision for taking that adverse action. And they need to cite the specific regulations that support the action that they're taking. And so the recipient needs to know why is this happening to my benefits? What's the basis for it? And it needs to be written in a way that is in plain language, that they can understand. And they also have to advise of a right to a hearing, method of the request to request that appeal, and that they have the right to represent themselves or to have an authorized representative. And an authorized representative could be, a legal service agency. It could be a family member, a friend. It could really be, almost anyone, that can serve as an authorized rep to assist with the appeals process. The notices also have to contain translation for individuals with limited English proficiency, and they need to be accessible to individuals with disabilities. Next slide, please. Just some more information on notice requirements. And I find that really the notice requirement is definitely a basis that, give rise to many appeals when there's insufficient notices. So this is definitely an area you can watch out for when assisting individuals who have received an adverse action or notice of action to their Medicaid rights. Definitely looking at the notice is a good place to start to ensure that everything is in there. So circumstances when enrollee can receive continued benefits pending the outcome of the appeal. This is called aid paid pending. The notice needs to also inform that they have the right to aid paid pending, that they can essentially keep their coverage in place while they're going through the appeals process. And we'll get more into the rules around that as well. The notice has to also be sent at least 10 days before the date of the action, except death, voluntary consent. If the beneficiary was admitted to an institution where they're ineligible, if their whereabouts are unknown and the mail is returned without a forwarding address, accepted for Medicaid by another jurisdiction. And then there's some other reasons which I've cited too that you can look into as well. So that's the breadth of the notice requirements. Now, how does this relate to unwinding? There's a lot to watch out for, I think, even prior to the public health emergency, but I think with unwinding, given the large volume of cases that state Medicaid agencies are initiating renewals on after, this long period of time, I think notices are definitely a top concern because there are some people who've been newly enrolled in Medicaid during this public health emergency who aren't familiar with the renewals process and how things should go and what their rights are. And some people may have forgotten during this period of time. So I think the notice requirement is definitely a stage of the appeals process that is definitely one to focus on during unwinding. So I think some top level concerns that advocates have right now are notices being confusing, not being in plain language, not being understandable, as well as outreach communications to inform people about this unwinding period and the steps that they can take and what to watch out for as their agency processes their renewal. Just notices that don't have enough information in it to, in the prior slide, inform the beneficiary of the action being taken, the basis for it, why it's happening, and what their rights are. Failure to include sufficient information on income or basis of eligibility, what kind of Medicaid program they're on so that they can understand why the adverse action is being taken. I think there's concerns with just having outright wrong information, this information that's just inaccurate about their rights and responsibilities during unwinding. I think there's concerns also about the failure to provide notice, right? So during this unwinding period and during the public health emergency, many people have relocated, they've moved, they've changed jobs, their income has changed, their assets have changed, all sorts of things relating to their eligibility. And so I think there's obviously a huge concern at agencies not having updated addresses to be able to to provide notice and not enough outreach to update addresses. And then also having wrong dates on notices, that's another concern. And so, definitely some things to watch out for. Now, under the federal guidance for the unwinding period, states do have an obligation to transfer electronic accounts where the state assesses potential eligibility. And this is specifically for people who are newly ineligible for Medicaid. So they do have to make sure that they are connecting that newly ineligible individual to their marketplace, whether it's through the federal facilitated marketplace or through their state-based exchange. One thing to just note, I think states are dealing with this differently. For states where, where it's transferred to the federal marketplace, just note that this really only transfers their information so that they can be contacted for outreach on healthcare.gov. It doesn't, connect them to coverage. It doesn't really do anything beyond that. So that's, I think, another major sticking point to watch out for, to make sure that people understand that, and that they, given the large volume of cases, that they may, need to be proactive in ensuring that they don't suffer a gap in coverage. And some states are taking some additional steps to make sure that they are, auto enrolled into coverage. So it's really different among states. And so that's why it's important to watch out for that. And then the other thing to just note that unlike the Medicaid renewals process for newly ineligible consumers, they will have to complete a whole new application on the federal marketplace. So there's not going to be a pre-populated form like they would receive in the Medicaid renewals process. So just another thing to note. Next slide, please. So let's go over a couple scenarios just to make sure we're understanding this. So just a couple hypotheticals here. Okay, so Benito has Medicaid and went to the doctor for a checkup. He provided the doctor's office with his insurance card. When the office processed his insurance information, they informed him that his Medicaid terminated the month prior and that he no longer has any insurance coverage. Unable to afford it, Benito puts the charge for the visit on his credit card. He had no idea that his Medicaid had ended. So what are his rights? So in this scenario, like we went over, his state Medicaid agency had an obligation to send him that advance notice about the termination of his coverage. He was supposed to get a 10-day notice letting him know so that he could request an appeal and try to get more information about the action taken on his Medicaid. Since he didn't receive that notice, he has the right to appeal, and he definitely should. The agency is also obligated to reinstate his coverage because they failed to provide notice. So that's one thing to note, is that if an agency fails to provide notice, that person has the right to have their coverage reinstated. And the agency, if they're still wanting to take the adverse action, they need to send a new, correct, sufficient notice to that individual, basically start the process over. They have to make sure that it's in compliance with the timeline that state has for allowing for an appeal request. That's fewer than 90 days. It could be 90 days or fewer, but not to be any less than 30 days to request an appeal. And then once reinstated, and assuming that he's successful at his appeal, that he was incorrectly terminated, Benito is also entitled to get reimbursed for the medical bill. Next slide. So just another scenario here. Taylor and Chris are both enrolled in Medicaid. They receive a one-page letter from their state Medicaid agency that says their coverage will end in 10 days. None of their information has changed since they were last renewed. There is no other information in the letter. Confused, Taylor and Chris attempt to reach their eligibility worker, but they have not been able to reach them. So in this instance, what should Taylor and Chris do? And what are their rights? Well, based on what we went through with the notice requirements, a one-page letter that just says that their coverage is going to end in 10 days is obviously not sufficient. They needed to provide the basis for it, cite the regulation that supports that decision, provide the details on why they're being terminated, especially if their eligibility information hasn't changed. So definitely an insufficient notice. And it also needed to advise of their appeal rights. So they did the right thing in trying to reach their eligibility worker to try to get more information. And so that was definitely a good step, but unfortunately they didn't know about their appeal rights. So they need to be advised of that. So in this instance, the agency needs to resend the notice with all the required information and immediately reinstate their coverage if they had terminated them. And so basically starting that process over again to make sure that they're providing the correct notice with appeal rights. So this is a lot of information, so I'm going to stop here and just see if there's questions.
Yeah, thanks so much, Skylar. There are questions. The first one is, this is a really good question. Does it count as having provided notice if the notice was sent to an address where the person no longer lives?
Yeah, so that's a very good question. And this can get a bit tricky because I know some states also treat return mail a bit differently. I think it kind of depends. If the address is the last known address on file, so that's what they have in their files, what they've verified through available data that they can access. And they send the notice to there, and let's say they get it back and there's no return address, they have satisfied the notice requirement. They can try to contact the beneficiary through other means to get that updated information. But if they've exercise those options and have sent that notice with the available info on file, they have done their due diligence in sending that notice. And that can be an issue sometimes with cases that does come up.
Got it. Thank you. Thinking back to one of your earlier slides when you were talking about when beneficiaries can appeal, you mentioned delayed eligibility determinations when the claim for assistance is not acted upon with reasonable promptness. Can you say more about what defines reasonable promptness?
Yeah, and again, this can be tricky because states can interpret this a bit differently. I need to see, I can look into more specifically the specific definition on reasonable promptness, but I do believe it can be tricky within states. But generally, state Medicaid agencies do have to issue a determination on an application within 45 days or 90 days if it's based on disability. And so, I would say if it's hit either of those time frames to just request an appeal. And I think that is right for an appeal if they've gone past those days. And, I think a lot of beneficiaries will kind of just wait and say, oh, I'll just wait another week, or, the eligibility worker said they're almost done, or I should hear in another couple of weeks. And I think it's important to just request the appeal, because the worst comes to worst is the issue gets fixed, they can withdraw the appeal. But requesting it also kind of forces the worker to, actually do something with the application.
Great, thank you. Why don't we go ahead and keep moving, but I'm going to keep sifting through the questions we've gotten, and we will keep trying to get to lots of those at the end.
Okay, great. All right. So how to request an appeal. Let's get into those options. So requesting a Medicaid eligibility appeal can be done online, via telephone, US mail, in person, or other commonly available electronic means. So that can include fax and other options like that, depending on the state. State agencies can require hearing requests be in writing. Not all states do, but some can require that. State agencies may not limit or interfere with the beneficiary's right to request their hearing. So what that means is, I've seen instances where agencies or counties maybe, are trying to work with the beneficiary to fix the issue and sort of discouraging filing an appeal. I've definitely seen that in several instances, and that's really that is definitely not allowed. They can always work on the issue in the meantime while the beneficiary requests their hearing. Like I said, just with the prior question, the appeal can always be withdrawn. There's no penalty for that, but they cannot interfere with someone's right to request a hearing. Next slide. And so there are ways for folks to get help, and this might be relevant to some of your work and how you can help individuals understand their appeal rights and connect to resources to help them with that process. Just to kind of first focus on what assisters do not have a duty to do. You're not obligated, you do not have a duty to represent a beneficiary in an appeals process, to sign an appeal request, and to file an appeal on the consumer's behalf. There's no obligation to do those things. And especially signing the appeal request or filing it on their behalf, I definitely would be careful with that, because that might, that could potentially represent, becoming an authorized representative. What you can do to help beneficiaries is to go over the notices with them, to make sure that they're just understanding the language, or you can look at it and think, oh my gosh, this notice is really confusing. This is not a good notice. And so that might also, help beneficiary understand that, something's wrong here. And this is something I should appeal and bring up to my Medicaid agency. Helping them understand the reasoning behind the action being taken so that they know what they can do to address it. And to go over their right to appeal, to make sure that their appeal rights are maybe even in the notice, right? So going over those timelines, making sure that they understand, for example, you have 90 days from this date on this notice to request this, maybe, helping them calculate the actual date. I know that's something that I did a lot for individuals, is making sure that they knew the deadline, the actual date that they needed to request by. Another big thing you can do is connecting them with their local legal aid organization that provide free help with issues like this. And so we've included the link where you can find those local legal aid orgs. For beneficiaries who maybe are homeless, or have inconsistent or no access to a telephone or internet, you could provide them a phone that they can contact the agency to request an appeal, or connect them to an area where they can access a computer to request that appeal. But like I said, just make sure you're clear that you're not signing anything, or that you're not roped in as inadvertently as an authorized representative. If there's someone who has accessibility needs or speaks a language other than English, you can, be by their side to ensure that they get access to an interpreter or an alternative format. to understand the notice. Next slide, please. So like I was saying earlier with the timeframes, it's really important to pay attention to those timeframes. And so that's why it's a really big help if you are helping individuals in this area to ensure that they understand the deadlines. So generally, an individual must be given a reasonable time to request. Again, kind of vague language here, but that is language in the policy guidance here. The time frame is established by the state agency. So states have different appeal timelines. It's not to exceed 90 days from the date the notice is mailed. And it must be requested by the individual impacted or by a designated authorized representative. And to become an authorized representative, there's usually a form that agencies have that needs to be filled out. I don't believe that it's, well, I can't say for sure if a state maybe has a verbal ability to become an authorized representative, but generally it's a form that you sign on to. So if you're an authorized representative or not. Note that if 90 days has passed since the eligibility decision, individuals may ask for an extension of time to file for an appeal request for good cause. That's an exception to this 90-day deadline. And that's if mitigating circumstances exist for why they did not file during the 90-day period. So again, this is kind of vague language here. There isn't a bright line rule on what is good cause. It's really if there's just like a really extenuating circumstance where someone, missed the timeline. Now, during unwinding, some states have temporarily extended their request time frame. So in some states, there's 120 days to request an appeal. Again, this is really only temporary during the unwinding period. Next slide, please. So let's go over a quick hypothetical. Cynthia receives a notice of action about her Medicaid coverage. The notice states that her coverage will end on the last day of the month because she is over the income limits to qualify. However, Cynthia's income has not changed and she remains under the limits. The notice contains the contact information for her eligibility worker and nothing else. Cynthia tries to reach her eligibility worker several times to fix the proposed termination, but cannot reach the worker. After several months, her Medicaid has terminated. After calling several numbers, she reaches her state Medicaid agency to discuss her termination. The agency informs her that she has to reapply because she is past the state's 60-day appeal deadline. What are Cynthia's rights? So I think there's quite a few issues with this. So first of all, there's an insufficient notice. There were no appeal rights included. And so the agency actually has to reinstate her coverage immediately. And if they believe that she is over the income limits, they need to resend a sufficient notice, but they have to reinstate her coverage. She can definitely still appeal. She can argue good cause because the notice was insufficient. She wasn't informed of her appeal rights. And she can also request aid paid pending during her appeal so she can keep her coverage while she's going through the appeals process. Because it was the agency's responsibility to have informed her of the timelines to appeal her appeal rights and where and how to do it. So rights during the appeals process. Prior to the state fair hearing, individuals have the right to review their case file. Their eligibility worker has to ensure that they can access that information and has to arrange for that. Beneficiaries have the right to examine all policies and documents that form the basis for that decision. So if someone's over income, they need access to the policies that discuss the Medicaid program they're in, what the income limits are. And so they have access to that information. Agencies also have to arrange for interpreters for individuals with limited English proficiency. That's both in their correspondence with the beneficiary prior to the hearing, and then they have the right to an interpreter during the hearing. They can also request an expedited hearing. That's also an option. If they can't wait that length of time for a hearing and it's urgent, usually that's if there's a medical condition occurring during the eligibility action that's being taken. They can request an expedited hearing, and that's if waiting for the hearing would otherwise jeopardize life, health, or ability to attain, maintain, regain maximum function. They have to ask that on the appeal request. And then if it's denied, they still have the right to a regular appeal. So they have to provide notice, and then they have to proceed and treat it just like a standard hearing. So they won't deny, they're not supposed to deny the hearing just because their expedited request was denied. Now, prior to the actual hearing date, and hearing dates can take, again, there's not really a bright line rule on when a hearing has to take place, although we'll get into the timeline for the hearing decision. Again, states vary on this. Some states can be really prompt, and some states can take, a couple weeks. It could take sometimes a month to get a hearing date. It just really depends on the state and their volume of cases. So it can, sometimes take, it can vary in timing. Now, before the hearing, the eligibility worker, the Medicaid agency also has an obligation to assist with an informal resolution prior to the hearing date. So basically, the parties working together to try to fix the issue. If it's an income issue or miscommunication about assets, they need to work together to try to see, okay, do we have this wrong? Do we have the wrong income information? Do we have the wrong asset information? Okay. Let's try to work this out, resolve the issue so that we don't have to go to hearing. And that helps clear up the dockets, and it ensures that, continuity of coverage is in place. Also, another thing to note, like I said, this is focused on eligibility, but there's a lot of types of appeals within a hearings division at a state Medicaid agency. So all that is to say, it's not the claimant's responsibility to know which type of an appeal they're requesting. The agency has to coordinate that. They just need to submit their appeal request. Next slide. At the state fair hearing, it has to be fair, and it has to occur at a reasonable time, date, and place. Again, kind of vague language here. So, there's some frustration with that, but there can also be some strength in that when advocating for folks and their appeal rights. It does have to be conducted by an impartial hearing officer, and the beneficiary must have an opportunity to bring witnesses, establish pertinent facts, present arguments without interference, and to confront and question adverse witnesses. So if a county worker maybe is testifying, they have the right to question that worker. They have the right to say, if there's an income issue, to present documents that show their income, things like that. They have the right to do that at their hearing. In-person hearing is not necessarily guaranteed. And in fact, especially due to the pandemic, many states are shifting to telephonic and video hearings. All that is to say, though, if a beneficiary does have maybe a certain condition where they need access to an in-person hearing, that can absolutely be requested. They do have the right to request it. It's just not guaranteed for all beneficiaries. So just something to note with that. Next slide. So here's another scenario here. Kim receives a notice stating that his Medicaid coverage will terminate by the end of the month because he is now eligible for Medicare. Kim does not speak English, and this is documented in his case file from when he first applied. He calls his eligibility worker to get more information about the proposed termination and to review his case file. He also asks for an interpreter. Kim's caseworker tells him in English that there is nothing he can do about the proposed termination at this point, but informs him that he can request an appeal. The worker ends the call. So what are Kim's rights in this scenario? Well, first off, the basis is just incorrect. You can have Medicare and Medicaid at the same time. That's not really a basis for termination. So he should definitely appeal. The caseworker also should have gotten him an interpreter when he asked for it, especially because it was documented in his case file. And the worker also had an obligation to explain in further detail the basis for why they were ending his coverage, especially because it's obviously incorrect, to try to fix the proposed termination. So, this error here could have been resolved with one phone call, but the worker failed to look into the basis and to explain that to him. The worker was also incorrect to say that there was nothing he could do about the proposed action, and was supposed to arrange for him to review his case documents because he has the right to request that. And so given that the eligibility worker does have an obligation for the informal resolution, it was incorrect to say that there's nothing he can do. So again, this would require some advocacy here. But these are things that do come up for people in real life. Next slide. So the appeals process and implementing eligibility decision. So just going over the sort of last kind of pieces of what the appeals process is. Next slide, please. So aid paid pending continuing benefits. I've touched on this a few times earlier, so let's unpack this a little more because it's really important. And sometimes it's glossed over here. So aid paid pending, it's when individuals can request, and then sometimes it's automatic that their Medicaid benefits continue during the appeals process until the decision is issued. So they maintain coverage during the appeals process. They have to request a hearing within the 10-day notice period before the negative action takes place for it to be automatic.
Skylar, I think that we have lost your audio, unless it's just me. Hang on one moment, folks, while we try and figure out what's going on. Really sorry, folks. We're trying to resolve the audio issue, so thank you for your patience.
Hello, can you hear me now?
Yes, thank you. Phew.
I'm so sorry. Yeah, my Zoom totally just shut down on me right now. So thank you for your patience. I need to go back over that. So aid paid pending is when an individual can continue their coverage during the appeals process. And it is automatic if they request it during the 10-day notice period before the adverse action takes place, it's automatic. But after that, they do have the right to request it. They always have the right to request it, but it's up to the agency to decide if they're going to grant it. And again, this is a point to advocate usually if there's like a really, serious health condition that they're navigating that requires access to care. That would, is an instance where you can make that argument, and you definitely should try. The worst they'll say is no. An agency must reinstate continued benefits if they take action without providing the required notice, as we've gone over. During unwinding, some states have made this automatic with no deadline. So a temporary rule. And so if if states got the temporary flexibility for the extended timeline to request a state fair hearing, then they're also required to provide aid pay pending without the deadline. So that's an important thing to know during unwinding. Usually, agencies are entitled to recoup payments from an individual if they granted aid pay pending, but the beneficiary's appeal was not successful. So they covered a service while they were pending the decision and they didn't get a favorable decision, like the determination was correct. They do have the right to recoup payments for that. During unwinding, some states are prohibited from recoupment, and that's if they've extended that appeals timeline. Now, all that is to say, again, all states are different, but I found that in many states, while they have the right to recoup, there are some states that have not made that a practice. So again, it just really depends on the state, but that is technically the rule. Next slide, please. Now the hearing decision. So what happens after the hearing is done? What happens next? The agency has to issue a hearing decision within 90 days of the notice of action. That's the general rule. They can request an extension, but that's the general rule. So the decision has to be based solely on the legal rules and the evidence presented. It has to be provided to the beneficiary in writing within 90 days of the hearing, of the hearing request. It has to summarize the facts and the regulations that support the decision. It has to inform about additional administrative or court review options. So if the person still disagrees with the hearing decision, it has to inform of additional steps that they can take, like requesting a rehearing. The decision is final and it is binding, but it may be subject to judicial review. Again, that's if you want to request like a rehearing, you can request that review. Next slide. And so just to summarize the key points to really take away is that individuals can submit an appeal in several ways, online, in writing, by telephone, or other electronic means. The agency or the county Medicaid office has an obligation to try to resolve the issue informally prior to the hearing. Individuals have a right to a hearing if they remain dissatisfied with the informal resolution. And the decision needs to be sent to the beneficiary within 90 days of receiving the appeal request. Next slide. So just a couple more scenarios and then we'll go into questions here. Keisha has Medicaid and receives a 10-day notice stating that her coverage will terminate at the end of the month because she's over the asset limit. However, Keisha's assets are exempted. The notice contains all of the required appeal information. The next day, she calls the state Medicaid agency and requests an appeal. Her appeal is entered into the system and the agency informs her that she will receive confirmation letters and more information about the hearing in the next couple of weeks. After 3 weeks, she receives confirmation letters and a hearing date. However, she learned that her Medicaid coverage effectively terminated. What are her rights? So in this instance, she called the Medicaid agency the day after she received the notice. That was the correct first step. And it sounds like the agency correctly processed the hearing request and they sent the letters, which is correct, but they did fail to give her aid paid pending, even though she requested it within that 10-day time frame before the adverse action was effective. So the agency does need to reinstate her coverage while she is pending appeal. She's entitled to that outright. Next slide, please. Just one last scenario here. So it's a little more fact intensive. On April 20th, Danny and his family received a 10-day notice of action stating that their Medicaid coverage will end after the last day of the month. The family's income has increased since their last renewal, but Danny believes some of their income is exempt and therefore he wants to appeal. Danny called the agency to ask for an appeal first thing in the morning on May 2nd. The request is processed and the family receives confirmation letters that they will receive a hearing date in the next couple of weeks. The next week, Danny goes to a follow-up visit for his cancer treatment with his doctor. He receives a bill for the visit and learns that his coverage has terminated at the start of the month. Danny and his family are still waiting for their hearing date. What are Danny and his family's rights? So you can see on the date here, he requested the appeal on May 2nd. He got the notice on April 20th. He requested it after the 10-day notice period. So he doesn't get automatic aid paid pending, although he still has the right to request it. It's just up to the agency to have granted it. An argument here that he could make for that is, that he's navigating cancer treatment and needs access to that. That's obviously a condition that requires consistent access to coverage. And so, that would be a very compelling argument to argue for aid paid pending. As for the income issue, which is the basis for the hearing, that really depends on whether or not some of his household income is exempt. And so he would need to demonstrate that and provide the documents for that. If the household prevails, he can also get the medical bills covered by Medicaid since his coverage was terminated. However, if he loses at the hearing, the agency technically has the right to recoup payments for any bills they covered during that time. Now, what if Danny got aid paid pending and the bill was covered by Medicaid pending an unfavorable hearing decision? Like I said, they technically have the right to recoup the payment. So those are some of the arguments that could be made and some of the ways that this scenario could shake out. And with that, we'll open for more questions. I'm sorry we lost a few minutes here.
No, we're glad we got you back. We're going to stay on for a few questions, and we understand if folks have to hop off at the top of the hour. But just a reminder that this session is being recorded and it will be available on our website in just a few days. So a few questions. First, can you clarify the difference between situations where somebody might be able to call the Medicaid agency to initiate an appeal versus circumstances where one might be required in writing? Or is there a difference?
Sure. There isn't really a difference. If the agency says, they have the right to request in writing always. If the state does permit requests by telephone, because like I said, some state agencies, can require writing. It just really depends on the state. And so if it's required in writing, then they do have to send it in writing. But if the state offers multiple options to request, either option is sufficient.
Great, thank you. Can you say a little bit more? We've got several questions about aid paid pending. Does everybody get this? How do you know if you can get this? Just say a little bit more about that.
Absolutely, yeah. This can be a little tricky. So aid paid pending is, like I said, it's always available. It's automatic in certain instances. Aid paid pending is provided automatically if the person requests that. Basically, if they request the appeal before the negative action takes place, so before the agency actually terminates their Medicaid coverage when they said they're going to do it in the notice, or shifts them to maybe a program with a premium, things like that. If they request it before that action takes place, they can get aid paid pending. That's automatic. They don't have to argue for it or request it specifically in the hearing or in the appeal request. Now, if it's past the date when the actual negative action takes place, so let's say their Medicaid terminates, but they still have, say, 60 days or 90 days to request a hearing, they can still ask for it, but they do have to specifically request it, and they do need to make an argument for why they missed the deadline or why they need it. So they have a compelling argument for like a health condition, or maybe they're homeless and they don't have consistent access to a phone or to a computer. Those are instances where, you can make that argument. I hope that helps.
That's great. Thank you. One other question here, and I think that's all we're going to have time for, but reminder to all the folks whose questions didn't get answered, you're welcome to email them to us and we will do our best to get through them. Last question. Can you say more about what people are able to review in their case file? Would this include things like screenshots from data being used to make an adverse decision?
That's a good question. And again, I think that might vary by state and how they, what they're storing and what systems they're using. I know that just varies so much across states, but they're able to examine, basically what's stored in their case file. So the information that the agency has on file for them relating to their eligibility. So the income information they have on file for them, and whatever documents were submitted to support that, the income information, asset information that they have on file. If there's like if it's like a citizenship issue, that the documents that they have on file relating to that, that's the type of stuff that they can review in their case file.
Great, thank you. We had so many good questions. I'm sorry we couldn't get to more of them, but we have run out of time. So next slide. So these are just a few of the resources that are available when you download the slides. There is a number of resources from NHeLP, as well as a recording of an adjacent but related resource, our Marketplace Appeals Process webinar from last year, which NHeLP also presented on. And this is a good companion to today's conversation. Next slide. So before we go, I just want to extend a huge thank you to Skylar for presenting today. We're so grateful for the content that you shared and for our partnership with NHeLP. This has been a whirlwind but fabulous presentation. And as I mentioned before, we will be distributing materials from today's session via email, and everything will be posted on our Beyond the Basics website, listed at the bottom of the screen here. We don't have any other webinars scheduled immediately at this time, but do sign up for our emails if you don't get them already. Go to our website to sign up to ensure that you hear about all our webinars and resources as they're available. If you have questions or need assistance with anything, please always feel free to reach out to us at beyondthebasics@cbpp.org. And with that, we will bring this afternoon's webinar to a close. Thanks again to Skylar, and thanks to all of you for joining us. Take care.